Hi, everyone. Welcome to our Facebook Live broadcast. I'm Steve Altition, Director of Client Partnerships at Pacific Cascade Legal, and I'm here with our founding attorney, Louis Landerholm, to talk about immediate danger and emergency child custody orders. Hey, Louis, how you doing today?
Doing great, Steve. How are you?
I'm doing well. This is a good one because it's something that when it's needed, it's really needed now. And so kind of, to start with, when, it says emergency, when can a person actually ask for an immediate danger order?
Yeah, so there's two times. Well, there's not two times, but there's two instances that generally an immediate danger comes up. But the standard is really that the child is in immediate danger at the time of filing. So there's the first analysis is what is the danger and did it happen when we're filing the motion for immediate danger. And so I can back up a little bit in Oregon, our only immediate filing, in the civil side, on the civil side of a divorce or child custody case when kids are involved, obviously, is that we file this emergency order. It is basically one parent takes the order, and there's two components or two different sort of time periods. One where there hasn't been an order previously, you do have to file an underlying case to get it. And at that point, you go in front of a judge and you explain in a declaration why the child is in immediate danger, and so that the judge will sign it. Um, you generally have to give notice to the other party that you intend to do so, and then you show up in court, and the judge will go through the facts and decide whether it's enough to file the or to sign the initial immediate danger. After a case has already been established and say you have a parenting plan down the road, then in order to file, you have to file a modification to go with the immediate danger
Got it.
in order to file it.
You were talking about making a declaration. Is that a declaration, a written declaration, or can you give actual testimony, or does the judge just go on what you're putting in the declaration?
Yeah, so it is a written declaration. Generally, this is a judge specific thing. Judges handle it differently. Some will just rule off of the declaration that is before them. Others will talk to the parties, especially if both parties are there. It is possible that the judge does ask questions. Most of the time, it's just off the declaration, though. But there are other instances like if DHS is involved, sometimes they will call a DHS caseworker to ask about what's going on. So it's a very sort of flexible process, and it's really dependent on the judge at the time, what they if they feel like they have enough to order an immediate danger or not.
And does that order have take effect then right away, kind of like a status quo order? Does it, the judge says, here it is, takes effect now?
Yeah, so it would take effect as soon it's in effect, but then it's effective against the other party as soon as they're served with the order.
Right. But if they're
Yeah.
there, if they actually come, then
Yes.
yeah.
Yeah. And then they would
Does
get the order, and it would be enforced at that point.
yeah. Does the person who maybe objects to it, who says not in immediate danger, do they get to file a declaration or some sort of written something to give to the judge?
Generally, there's not a written declaration from the other side. Again, this is a very judge specific thing. Sometimes the judge will ask the other side their position, but normally that's reserved for a hearing that happens later, generally within 14 days, of the other person challenging the immediate danger and asking for a hearing on it. So
Got it.
that's the evidentiary hearing, to be able to prove what you put in your declaration. So
Got it.
there's two components. It's got, sort of like a restraining order in that you go and you get an initial order from a judge, typically, then it gets served when the other side says, hey, I don't agree with this. I want a hearing. Then at that hearing, that's when all the evidence comes out and both sides would tell their side of the story backed up by what they can prove. And then ultimately the judge would say, yes, still immediate danger, maybe modify the parenting plan some or whatever it may look like, or no immediate danger. And then it would revert back to either the existing parenting plan or no parenting plan at that point.
Got it. So what is immediate danger? It's one of those phrases that you kind of go, well, I think I know it when I see it.
Well, yeah, that's what we talk about all the time. What is immediate danger is it is subjective. Um, it is hard to predict at times what one judge will determine immediate danger and what another judge will determine immediate danger. We have had cases where we can prove drug use by one parent, while in, possession of the children, but because other adults were around, the judge said no immediate danger. So it's a high bar for what an immediate danger standard actually is. But then we have other cases where maybe the evidence isn't quite as, sort of ironclad as we, would think in other cases, and we do get them ordered. So it's a really hard one to predict. It's really a factual analysis, and there's a lot of um, conversations before we take one about like, okay, this is what we're looking for. This is what we think this judge will care about. And do we want to take this immediate danger or not? Because it's a big deal to file, to file that motion. Because it's not like it's hey, it's best interest. I just think what's best for the child. No, this is like, no, the kids are in immediate danger at
Right.
that time. And if something doesn't happen, then they're in a dangerous, situation.
Right. The has the legalization of marijuana kind of put a twist into this? Or is, because I know in the old days, I mean, any sort of drugs is like, okay, this is bad. Now you're bad. Now we're going to try to stop it. But what about things like that? I mean, if it's legal now, do judges look at it a little differently than they used to, or do some and some don't?
Yeah, and I think, you say than they used to. I think there's even before it was legalized, marijuana was moving towards, acted like it was alcohol,
Yeah.
where the substance by itself wasn't as as worrisome as say, illicit hardcore drugs. Um, back in the day, obviously marijuana was frowned upon because it was illegal. In today's world, we basically look at it, and most judges look at it the same way that alcohol is.
Yeah.
Alcohol is legal. You're allowed to, know, you don't want paraphernalia around kids. You don't want them to have access. It is a little bit different from the standpoint that, depending on which form, marijuana is, obviously the effects can, potentially last a little bit longer. So it really depends on what's happening. Driving under the influence, regardless of what it is always going to be, a concern for a judge. But marijuana is not is not going to be a case where somebody smokes marijuana, therefore the kids are in immediate danger.
Right.
To the same as somebody drinks alcohol, the kids are in immediate danger. It's like, okay, what's happening with the alcohol use? What's
Right.
happening with the marijuana use?
Right.
And even with more hardcore, illicit drugs, the same analysis can apply. What people do on their own times, maybe a judge doesn't care about. It's what's happening when they have the kids. So it's really dependent on the facts.
Is there any such thing as a pre-immediate danger? Like my spouse called and they're supposed to come over tomorrow night, but he's doing this bad things, and it, it's not actually happening yet, but it's like threatened to happen. Can that produce immediate danger?
Again, it's, predicting what judges do is the hardest part of the job.
Yeah,
Um, you know, I guess it really depends on what the threats are and what the circumstances are. It could be,
yeah,
if somebody's threatening to, and we have it in writing that they're threatening to flee to Florida, maybe that's enough for an immediate danger. But then in other instances, we've seen that, a judge doesn't find the threat credible, or maybe because it hasn't, it's a catch-22 a lot of times, right? Because a threat by itself doesn't raise to the level of an immediate danger. If the more credible the threat is, then it could be. But it brings up a good point on, like, people will say, oh, well, they won't let me see the child, like they're withholding from me. But if you don't have an order that they're withholding against, that's not enough for an immediate danger either. There's different remedies for that. And so, it's really factually dependent, and talking to attorneys who deal with them every day is the best way to start the conversation, because there's no one size fits all for immediate danger.
right. And it sounds like one of the things that you as an attorney really help is that if a judge is going to only read something, to make sure everything is in there. It feels like, if someone goes on their own and they just sort of scratch two or three lines that made, and the judge doesn't ask questions, they may not get their order.
Yeah, so that's definitely important, the what's in the declaration. But also, because the hearing comes pretty quickly, then using that time where we know that a hearing can potentially come, we can get ahead of the game to start prepping for that hearing, to
Yeah.
gather the evidence. Because it's not enough to just say these things. You actually, because it's, the standard when you end up in court is clear and convincing, which is a high standard of proof. Um, because you have to prove that the kids are in immediate danger by a clear and convincing evidence, standard, then we have to have the evidence to back it up. So it gives us time to jump in and start gathering the evidence, talking to witnesses, gathering DHS records, CARES records, provider records, whatever it may be, to be able to show why a child is in immediate danger.
How how long does the order last? And what I'm kind of thinking of is mostly this comes to light and with like an emergency custody order or something. And if that emergency custody order, is it only about what is going on in the immediate danger issue, or can it be a more encompassing one that would generally last until the divorce is completed?
Yeah, it depends. It can be modified. The immediate danger order stays in effect until the judge says it's not in effect anymore. I mean,
Yeah.
essentially is the answer, right? So it either is in effect for perpetuity if nobody ever challenges it. It's in effect until further order of the court. And so unless a judge puts a timeline on it and says, it's no longer in place, it can remain in effect. And because the other party would have to challenge it that, there's no longer a danger. And so then it would go away at that point.
Could something like not doing things be immediate danger? And the one I'm thinking a lot is sometimes parents talk or fight about their child's health, and if they may be suffering from something, and one says no, and the other one says yes. And so one of the parents is just neglecting you know, medical treatment for their child. Can that be immediate danger?
Sure. Yeah. It's not the traditional kind of immediate danger, but we've had those cases, and by failing to follow doctors' recommendations, it has to obviously be, more than just I wanted this procedure to happen.
Yeah.
It has to raise to the level of this is danger to the child. So again, it's a subjective analysis to, what is a dangerous situation. But it can be if one party is basically preventing treatment that is, necessary and, normally not life saving, but, a
Yeah.
necessary, sort of procedure that we can't wait for, say, a modification to run its
Right.
course or a different type of hearing to run its course. So the judge could jump in and order that. Yes.
Yeah. This is kind of a dumb question, but I'm going to ask it. When we're talking about immediate danger, we're talking about immediate danger to the child,
Yes.
not to the spouse. That's a whole nother set of
Correct.
temporary orders.
Yeah, that'd be like a restraining order or temporary order, and so yes, it's only the children are in immediate danger at the time of filing.
Got it. And it doesn't have to be, or I should ask, doesn't have to be just against the spouse. And I'm just thinking, like, if a spouse decides to go to Vegas for the weekend and leave his kids with, a bunch of druggies, can that, it's not the spouse who's putting him, well, I guess maybe it is putting him in immediate danger. So but can that flow to what other people are doing that the spouse should have prevented?
I mean, ultimately, because the court can only order the two parents what to do, if one parent is making a decision that is putting the kids in danger, regardless of what that decision or action is, the court can find immediate danger. So, yeah, leaving with, I mean, you leave child with somebody and child abuse occurs, and then you go and leave that child with the same person, that's going to be immediate danger. You as the parent, decided to leave your child with somebody who you knew had abused the child before. I mean, the court can only tell that parent what to do, and so that action or inaction can definitely raise to the level of an immediate danger.
Um, Last question, sort of. It feels like because this is immediate and it has to be done right and it has to be done quickly, that this is not a great DIY kind of a situation where you should just try to handle this on your own. Um, because you could do all kinds of things that could, go wrong. Plus, I hear a lot where people throw this term around where it's really maybe not immediate danger, but it's more like just a way to get the kid to get custody. What are some of the pitfalls or the consequences of doing yourself wrong or doing it knowing that it's not really the situation? That can get you into trouble.
Yeah. Um, Judges don't like that. It's the long and the short of.
Yeah,
Uh,
the short and sweet, don't do it. I like
yeah.
it.
Immediate
Uh,
dangers are ones that we see a lot of parties who are unrepresented file immediate dangers. Um, you know, the ones where people just don't know and they don't know what the standard is and maybe it fails, that's not necessarily going to backfire as much. But the ones where, a party goes to the internet, how do I get emergency custody, of my child because I don't like what the other person's doing?
yeah.
And then in a declaration, they either, not straight out lie, but I mean, sometimes straight out lie, but other times just stretch the facts so that it sounds worse than it is,
Yeah.
get an order, that can backfire huge in front of a judge, because you're going to typically be with this judge, depending on the county, through the course of the underlying case, and abusing or using a statute or the court to gain an advantage is not a good place to be in for a final, for a final resolution and a final ruling. Because you remember, you either have an underlying modification or you have an underlying case moving. And so that judge is going to make a different determination in most instances at some point.
Yeah.
And they find that you either perjured yourself in public in court documents, which it is perjury, you can be held in contempt, or it just the judge feels like you were using it to gain that advantage, then it can definitely backfire, and the judge can rule the other way because of that.
Yeah. For the rest of the case, you're not considered credible.
Right.
Yeah. That's terrible.
Yeah, credible, definitely, even reasonable. I
Yeah.
mean, a lower standard of reasonableness. Judge wants parties to be reasonable, and so
Yeah.
if they can find somebody not credible, that's really bad for your case.
Yeah.
But even just the judge feeling like you're not the reasonable party can definitely backfire.
So, last one. This is not a subjective term. It's not, I think it's dangerous, so it is. It's not that. It's a term that is everyone has to think that's in danger, or any reasonable person has to think that's in danger.
Yeah, in most cases, the way I like to say it is that the judge has to think that that the kids are in immediate danger, right?
Yeah.
Because nobody else in the world really matters. It's really
Yeah.
just the judge who you're in front of. So,
Yeah.
well, yes, it's we try to impart more objectiveness, when we're talking to people, because we see hundreds and thousands of them, so then we apply them to the facts. But really, it is a subjective standard from the standpoint it's what the judge feels like is immediate danger, but they're trying to make it more objective by raising it to the level of like what is a dangerous situation. And so that's why they're so difficult to predict what's going to happen.
Yeah. Wow. Oh my gosh. This is a lot of information, and come out of anything of this is don't try to do it yourself. Get a good attorney, give you a call, because you'll give them a free consultation to start and let them know kind of what their case is about, what it costs, and all that good stuff.
Yeah, absolutely. Just knowing the ins and outs is 90% of it, and then working through the facts to determine if there's enough for an immediate danger is really important.
Yeah. Well, thank Louis. Sitting down talking with us today. Immediate danger, emergency custody, all of those orders are fraught with issues and have to be done right. So thank you for joining us today and talking through what they are, when you can use them, and how you can use them.
Yeah, absolutely.
And everyone else, thank you for joining us today. Anyone has any further questions, feel free to contact our firm. We can get you connected with an attorney who can help you. Stay safe,